All right. So I believe that the panel was just started. So dear colleagues and friends, welcome to the SIEL 2021 conference on rethinking global economic governance. I believe that you all had a wonderful first day of roundtables and this kind of panel discussion early morning, networking and other sessions. My name is Ching-fu Lin. I'm an associate professor of law at National Tsinghua University in Taiwan. It's my pleasure to moderate this fascinating panel on the timely theme of law and technology, as well as IEL, that is when intellectual property meets artificial intelligence. And we have two excellent speakers today who will shed light on the interesting and important issues on AI, innovation, and how law may adapt to accommodate technological changes and developments. Unfortunately, our third speaker, Kishor Dere, will not be able to join us today. So we're going to have a rather small panel today. Fortunately, both Mariela and Juliya are great scholars and excellent speakers. So I'm sure we will have a cozy and fruitful discussion today. Before we kick off, I would like to let you know that we have this virtual conference room until 12:30 p.m. Central European Summer Time. So we have ample time to have presentation and discussion, given that we have only two speakers today. However, the SIEL organizing committee has suggested that we keep the presentation concise and reserve more room for conversation. So I'll kindly ask our panelists to refrain from giving a long speech, but engaging in debates and interactions among ourselves and with the audience. Last but not least, please bear in mind that we have a public chat and Q&A functions to your right. As you can see, please feel free to use the public chat function anytime to raise questions or to give comments. We encourage you to also use the Q&A function to ask questions via video too. Without further ado, let me invite our first panelist to speak. Our first panelist, Dr. Mariela Eletti de Amstalden, and her co-author, Professor Burkhard Schafer, who is on annual leave and not able to take part here personally today. So we have only Mariela. Mariela is a visiting researcher at the Scottish Centre for IP and IT Law, University of Edinburgh Law School. She focuses on legal implications of innovations and intellectual property rights in the global economy, biotechnologies, food and public health law and policy, and the intersection with IEL and global governance. She has also served as senior lecturer in public law at the University of St. Gallen, as well as postdoctoral research fellow at the UBC Law School. I'm glad to know that we have quite a few shared interests in terms of research, and I do look forward to her talk on brand distinctiveness, AI, trademark law, and the TRIPS agreement. Mariela, the floor is yours.
Thank you very much. Let me try to pull my slide.
Share your screen.
Yeah. With you. So thank you very much again, Ching-fu, for this wonderful introduction. I missed a bit of it due to connectivity issues. It's wonderful to be presenting at this SIEL Global conference today. And as you previously mentioned, Ching-fu, I will be speaking today also on behalf of my co-author, Burkhard Schafer, about some of the legal implications of innovative technologies for IP rights. And in particular, I will be addressing the new phenomena of autonomous intelligent shopping agents, or AIs, as they intersect with trademark law. So increasingly, our shopping behavior is influenced by software that either implements our shopping decisions, assists us in varying degrees in the decision-making, or predicts our needs and desires and execute orders on our behalf autonomously, or at least semi-autonomously. Devices with voice assistants such as Apple's Siri, Amazon's Alexa, or Google's Nest Mini are forecasted to overtake the world population by 2024. At the same time, these AIs are expected to grow their global revenue almost tenfold in the next few years, reaching $126 billion by 2025 alone. So rather than visiting a real shop in the market to buy a product, human consumers are increasingly instructing AIs to purchase their desired products in the online marketplace. So our exploratory research identifies a wide set of normatively relevant processes that underlie the emergence of AIs as new intermediaries and examines possible implications for trademark law under the TRIPS agreement. Focusing on those issues where continuities and discontinuities between machine and human intelligence are most pronounced. This research is premised on two main hypotheses. One, and more generally, that the continuous maturity of artificial intelligence is acting as an accelerator of an already ongoing paradigm shift in global economic governance, whereby principles are favored over rules. Two, and more specifically, that the increasing use of AIs as they interact with human intelligence requires a recalibration of fundamental concepts of trademark law, such as distinctiveness, likelihood of confusion, and average consumer. For human shoppers, trademark law is quintessentially a response to all too human cognitive failures. We have limited time, limited attention spans, limited memory, and an ability for pattern recognition that on the one hand is highly evolved, but also prone to manipulation. Brands, so it goes, provide a tool to facilitate the decision-making process involved in the exchange of goods, allowing us to discern between different products on offer. AIs have a similar objective to trademarks. They try to simplify the world for their human users, reduce human cognitive load, and help humans make better and more informed purchase decisions. What's more, AIs are potentially not encumbered by the cognitive limitations I just mentioned. They are faster, do not tire, and have potentially unlimited access to data. And while their ability to recognize patterns is not yet on par with humans, they are also less likely to fall for at least some forms of deception. So do we still need trademark protection in these scenarios? At its core, branding by means of trademarks provides an essential tool to differentiate a particular product from other similar products in the same market. Trademarks serve many functions, the most important of which is arguably their ability to provide a guarantee of origin. This source identifying function of trademarks was first theorized almost a century ago by Frank Schafer. Displays four key elements: selling power, perception, use, and distinctiveness. We focus here on the latter element. In that vein, what does international IP law say about distinctiveness? Let's look at Article 15.1 TRIPS in particular. Under this provision, a sign will be trademarked if it is inherently distinctive, displaying an ability to distinguish products of one enterprise from those of the others. In cases where this inherent distinctiveness is not present at the time of registration, members have the regulatory prerogative to provide within their national laws an option to register trademarks that became distinctive for use. In its sentence 1, Article 15 TRIPS appears to suggest a stringent standard of sign distinctiveness, demanding it to be inherent by using the language shall, as opposed to sentence 3, as you can see on the slide, which makes registrability dependent on distinctiveness acquired through use, using permissive language with may. In both cases, however, the trademark capability of a brand sign must entail an acceptable level of distinctiveness to come under the purview of TRIPS. Our reading of Article 15 TRIPS is confirmed by recent case law. And here, please bear with me, there is a lot of distinctiveness coming up. In Australia plain packaging, the panel held that brand distinctiveness has to be present prior to registration to constitute capability, as this trademark capability must exist at the particular moment when that registration is occurring. The appellate body upheld this view, stating that Article 15.1 suggests that in terms of eligibility of registration, the norm is the presentation of signs that are inherently distinctive. Here, the appellate body appears to suggest with a cautionary note that the distinguishing function of trademarks does indeed relate to a potential likelihood of confusion arising out of the conduct of unauthorized parties, as it is provided in Article 16 TRIPS. In other words, distinctiveness as an essential element of the source identifying function of trademarks bears relevant primarily for registrability purposes under TRIPS. Of course, if there is no trademark registration, then there are no trademark rights conferred under Article 16 TRIPS. So what are the implications of these findings in the context of AIs? Applying the rationale seen in Australia plain packaging to AIs, trademark rights would not be infringed in cases where distinctiveness is lost due to an inability of the AI to properly distinguish one brand to another. Similarly, recent case law as it relates to online search engines and platforms suggests the same result under EU law. However, this outcome is unsatisfactory, as it leaves trademark rights holders exposed to a number of risks, not least neural attacks. Attacks against neural networks that result in false positives and false negatives could lead to intentional misidentification of patterns that would further contribute to a loss of distinctiveness. Allow me to illustrate. While autonomous intelligent shopping assistants are by now a mature technology, they still experience rapid technical evolution. Changes that far outpace the cognitive evolution of biological beings that has taken place over millennia. For instance, human perception of color and smell has not changed since the inception of TRIPS, or indeed any trademark regime. By contrast, both color and smell perception are active research fields in AI and are likely to see rapid improvements. However, based on this rather conservative character of Article 15.1 TRIPS, it is not possible today to preemptively register trademarks that are currently undistinguishable for humans, but are likely to be distinguishable by near future systems. And conversely, in the first case, the new sign would not constitute trademark capability, excluding their trademark holders from their exclusive rights conferred. In the second case, the brand distinctiveness existent at the time of registration may vanish at the point in time when the brand encounters an AI in the online marketplace. This is so primarily because the less a brand is recommended to future human consumers through AIs, the less sales are generated, directly affecting the selling power, use, and distinctiveness elements of the source identifying function of trademarks. This dual aspect of AIs, less in need of protection for some scenarios and more in others, forces us to entertain the idea of recalibrating key concepts of trademark law. So in a nutshell, our preliminary analysis suggests that a sui generis framework is not required at the global level at the moment because available trademark rules allow for sufficient flexibility in accommodating the peculiarities of the new technology. As a result, the first implication is that applicable international economic law must display, and indeed does display, a margin of appreciation that allows for national judicial decision-making in line with rapidly changing consumer behaviors. This degree of latitude needs to be responsive to local conditions, especially because as of today, AIs are all too often projecting the cultural and social norms of dominant market players, mostly found in the developed North, aka Silicon Valley. Here we see a critical, more efficient role for a principles-based approach to AI in global economic governance. Having said this, we also emphasize the need to recalibrate, as I mentioned earlier, fundamental concepts of trademark law, particularly distinctiveness, likelihood of confusion, and average consumer, to ensure appropriate trademark functionality. Absent this, trademarks in the context of AIs risk becoming descriptive terms. Many questions remain open, but I'm going to leave it at that for the moment. I thank you very much for listening.
Thank you. Thank you so much for such a great talk, Mariela. It's important to see the rise of ISA, autonomous intelligent shopping agents, as intermediaries between the consumer and the vendor. And I'm so pleased to see that you argue that there is a room for recalibrating general principles of trademark law as well as fundamental concept on the TRIPS agreement. I believe that we have reflections and questions in response to your insights, but let us have our second panelist first for Juliya to speak. Dear members of the audience, please hold your breath for the second panelist and then the discussion sessions in a bit. So our second speaker, Professor Juliya Kharitonova, is a professor of legal science, head of Research and Education Center for Legal Studies of Artificial Intelligence and Digital Economy, as well as professor of Business Law Department at the Law Faculty of Lomonosov, Moscow State University. She is also a member of the Scientific Advisory Council at the Arbitration Court of Moscow. She focuses on civil and digital law, business law, and legal education, and we'll be talking about AI, technology, and law, challenges of our time. Juliya, the floor is yours. Juliya? Seems to be disconnected. Please bear with us. Let me try to connect with Juliya for a minute. Yes, we just saw Juliya, right? Juliya, could you share your screen again? Yes.
Yes.
You're back. Can you share your screen again?
Once more, please.
That'll be good.
Yeah. Can you see it?
Not from my side.
Yes.
I can't see your video or your slides yet.
Can you see the presentation?
No, not now.
It's in the progress.
Can you go on? Can you go on stage? Go on stage. Yes, we can see it now. You can project your slides and get started whenever you are ready. Juliya? Please. Sorry, folks. Let me check with our technical support to see if we can have Juliya back on stage so she can present.
Okay. if you can hear and see me,
Yes.
maybe
Yes. Now we can. Now we can
I
see
shouldn't.
you.
Yeah, maybe I shouldn't use my presentation, not to waste the time. So
would you like to try again? Just to click the share function.
yes, if it's possible, because you see, can you see? I don't know.
No, we can't
No,
see that.
Just let me to represent my.
Okay. Would you like to send the slides to me, or you
Yes,
just go ahead
yes.
with
Maybe later, because
Okay.
it's not so important just now. Yes.
Okay.
Let us not try this time.
All right.
So
Sorry for the technical
thank you.
issues there. Yeah, go ahead, please.
Thank you very much for this opportunity once more. And our section for today is intellectual property meets artificial intelligence. Thank you very much to Mariela for this exciting report, because it was something unexpected, something new for intellectual property law, because part of this report was about unfair competition, but also it was about IP rights. And my point of view in this report, in this speech today, is about digitalization and some issues, some problems for law, for IP law at first time, for deciding the most important question. First of all, it's for me about creativity. We can see many discussions now about creativity of AI technology or AI creativity as well. And so in Russia, we've got some ideas about this moment, but not only in Russia, of course, because, Russia has adopted a national strategy for the development of artificial intelligence 2030. We are not the first country with such agenda, of course. As I know, about 30 countries discussing now the same strategies for the states, and about 10 others are working on it, on this way. So about a year ago, in Russia was represented this Russian national strategy on AI 2030, and they prepared it after some in other countries. So I can say that some problems of our strategy is the same for different countries. For example, it's US, it's China, it's the Netherlands, France, Japan, and so on. And Russia has approved the national strategy because it was necessary for our legislation. So the strategy 2030 reveals the concept of artificial intelligence like it is as a set of technological solutions that allows simulating human cognitive functions. I think it's a very important point, including self-learning and searching for a solution without a preset algorithms, and obtaining results that are at least comparable to the results of human intellectual activity when performing specific tasks. And first of all, we can see, like Mariela said just now, it's for business, for decision making. It's AI for decision making. It's something very practical. But another point of this strategy, that AI can create something that's comparable to the results, to the piece of works that protected under copyright, under Berne Convention, and so on. It's something creative objects. And it's the problem, I think, because according to many acts in different legislation, for example, in Russia, of course, civil code, we've got some article about what is the copyrighted object. Actually, I've said somewhat about Berne Convention for the protection of literary and artistic works, and so on. And it's about creativity. Especially for Russian legislation, we can say that the problem is about the creator. Actually, in many countries, like in Russia, they can say that the creator for getting these exclusive rights is only the individual personality, is only creator like a citizen, and so on. Maybe that different businesses decided to get some protection of results prepared with creative AI, we can say so. But in different countries, that was a very discussable question. But now they can say that it is not the copyrighted products at all. According to the international legislative, according to the national and local acts, it's not the object of the IP rights. So I think the first policy, the first program point for discussion for today is the possibility to provide some rights to businesses who invested to the AI development programs and other results. It's very expensive, of course, and it's necessary to support this industry. But I think it will not be IP right like in Berne Convention, in other points and international legislative, but it will be sui generis rights. And in this point, I agree partly with Mariela's idea about sui generis for AI regulation. We can see that it's not the same like human creativity, but it's also something I think unexpected too. I say not only the business decision making, but also about creative industries using AI technologies. Another point for the discussion, for our ideas for tomorrow, for today, is about data. In both cases, for businesses, for management, for decision making, and also for creativity with AI technology, we can say that this technology uses big data, of course, and it's necessary to remember that sometimes it's personal data. There's this special regime, legal regime of using it. And of course, we can say that it's different points to use data, exactly personal data, for making decisions, for target ads, and so on for businesses. And another point, it's about using data, especially, and not only personal data, for creativity, because in many museums in the world we can see something interesting. Then artists uses personal data, uses photos, pictures, and I don't know, tracks of sets of smartphones for making something interesting like pieces of art. But it's depends the legal regime, the legal decision of using this data, I think depends on the aim of the using, because creative industry, it's for artists, for literary works and so on, and it's an object of IP rights. And after that, we can see that business making decision systems and so on, it's for making money at all. So the second point of my report for today is that it's necessary to remember about personal data, but the regime and the opportunity to use it will be different for creative industries with AI and for business decision making. As I say, if we are saying about the opportunity and some frameworks for business using the data, especially personal data. So I've got much more questions than answers. I'm trying to discuss it with our audience, and maybe we've got some questions about it. Thank you very much for your attention.
Thank you so much for the great talk, Julia. I've learned a lot from both of your insightful presentations. So members and dear friends and colleagues from the audience, please feel free to use the public chat and Q&A function with the speakers with questions or any comments that you have anytime. Let me see if we have any immediate questions or comments from the audience. If no, I mean, we can wait, but if no, we can either encourage our panelists to, you know, to have debate or, you know, kind of interchange with ideas with each other, or I can also take the advantage and privilege as a moderator and share my 2 cents. So maybe I can go ahead a bit to see if we can bring up and warm up the roundtable discussion. So I really learned a lot from both of your presentations, and both your papers actually I have read with pleasure, and both of them evaluate the issues about the interplay between emerging technology and law. Mariela talks about the rise of ISA as intermediaries between the consumer and the vendor, and you know, as I just mentioned, talks about the possibilities of redesigning, reconfiguring general principles and ideas about trademark law, as well as the concepts under the TRIPS agreement. And then Juliya talks about how AI is driving innovations and how, you know, how to protect primarily in terms of copyright law and others, the results of the application of AI and developments of AI under existing law in different countries, as well as different paths for standardization. And both of you seem to assume, like the conventional wisdom on law and technology, that law is always lagging behind technological innovation, the so-called pacing problem. However, technological developments, including AI, are socially constructed and developed within a given legal and governance framework as well. So there may be other ways to accommodate emerging technologies under the existing legal system, or technologies also developed around the existing rubrics of law and regulation, so as to avoid immediate barriers or punishment or any sanctions from the existing law and regulation. So if we see this as an interactive, dynamic relationship rather than a linear relationship in which law always lags behind technology, how would you shape your, you know, like your general sense and also your arguments here? And also with that, how do you agree or disagree with each other here in terms of your ideas about how emerging technologies pose challenges to law and how law should kind of adapt and respond to that challenges of technology. Maybe any Mariela or Juliya, if you like.
My goal first, Juliya. Thank you very much for your presentation, Juliya. I really enjoyed reading your paper and now hearing your presentation. And thank you so much, Ching-fu, for your comments on our paper as well. This is such an emerging new field of international economic law. There aren't many of us dealing with AI as it intersects with international economic law, and I think it is a discussion that needs to be had. We cannot avoid it. We can just delay it. Perhaps in terms of the presentation that Juliya just made for us, I think data privacy is a big topic, and that's something that it is outside our paper at the moment. It is the big elephant in the room. We know as the technology operates that AI requires massive amounts of data to be fed, and also that raises ethical questions about biases. Whose data is that AI being fed? What are the implications of that data? Personally, being based in Switzerland, I take my data privacy very seriously. That is something that we consider of paramount importance. However, I do have a certain lenience or tendency to help out AIs and say, look at the data I am producing online. We're online almost 24/7, and use it for something good. I want that AI to be as less biased as possible. I want that AI to be as accurate as possible so that it can actually help us. Now, how can regulation and law in general help us achieve that goal of social benefit in a way? I think that is something that needs to be discussed further, also with digital legal experts that have more awareness on the way big data is operating, and we need to have conversations that are outside the silos. We need to have this intersectionality when we deal with new technologies. And it's not only for AI, it's for all types of emerging technologies. We need to get used to thinking outside the box in this sense. And as regards perhaps to the pacing problem that Ching-fu was mentioning, it is a very valid thought to think about law and technology as an iterative process and not a one-way street. So we're actually trying to get good at it in the way we feed both the technologies operating and the current legal systems that we have to deal with it. That doesn't preempt us to conceive perhaps sui generis frameworks, as Juliya was suggesting. I personally think that's not yet the moment for AISAs in particular, but there might be other aspects that intersect with IP and AI that might require some kind of sui generis legal framework that can also include the concerns of businesses or of the private sector, who is at the end of the day driving forward these technological advancements. And with that, I think I'm going to leave it up to Juliya to perhaps pick up on some of the points that I raised.
Thank you very much for your opinion, for your comments. Actually, I understand that it's a very deep problem for us, for all of us. And I appreciate that your focus was only on TRIPS and trademarks. It's very convenient. It's very interesting, and as I understand, it's sometimes it's unexpected. But if I say about data, I mean it was the idea after the reading your paper. Actually, it's all these points, all these problems. It's about data, of course. international problem is data, not only personal, maybe in other data, commercial data, and so on. And from time to time, AI technology, AI systems can use data for making some decision, for making business and so on. But in another plan, we can see that AI systems can use data for making piece of art. And it's for me, it's necessary to see the difference, and it will be a different legislation. I think, I hope so, because for example, they can see that they have the new something new like digital art, and from time to time they've got these problems because, for example, in US you can prepare something interesting using Insta photos, for example, and you can exhibit in Moscow the same picture, actually picture, digital but picture, and you can do it under GPDR in Europe. So it's a problem, but the main point of using these personal photos, personal pictures, not making benefits, you know. And I think we should understand that it will be new legislation. It's necessary to make it, to prepare it, but it will be different regimes for different aims of using data, and it's related to the problem of AI. And of course, I think that many lawyers don't like many new acts. Yes, it's not pleasant situation, but AI is the problem that it's so different in many relationships, and it's necessary to make something new. But I agree that it's necessary maybe wait. Sometimes it's very very important to wait, not to prepare something new in like act, like even draft and strategy, because it's very high developed industry, and from day to day it's something new in this system, in the technology of AI. So I think it's a problem, all these problems for future, of course, but we should be prepared. We should discuss it to be prepared to make legislative more comfortable for businesses, for artists, and of course for customers.
Thank you for the fascinating interaction and conversation we just had here. And we just received questions from the public. We have one question from Professor Vandenbosch and one from Ms. Godard. Would you either Juliya or Mariela, would you like to respond to the questions from them?
If you don't mind, I might make reference to the question from Professor Peter Vandenbosch in respects to rules and guidelines on technology transfer relating to AI. To the extent I'm aware of, I know of conversations happening at the WIPO level. So at the international level, the conversation is taking place. I don't think we're nowhere near guidelines or let alone rules agreed on this, but at least the conversation is happening. The discourse is active, and I see a lot of stakeholder involvement in this regard as well. At the national level, there are different paces, let's put it like that. I see from the UK, they're fairly advanced in terms of AI and law, AI and IP law, and the conversation has matured in the meantime. We haven't had a lot of case law jurisprudence on this, perhaps as I mentioned briefly during my presentation, there is some case law at the EU level, at the EU law level in terms of online search engines, Google and others, but we haven't seen this particular development in terms of transfer knowledge and of AIs. I hope that matures within the next few years. It has to, otherwise we will be left with less tools that we could possibly already have now. So it's important, the stakeholder involvement, I think it's key, and also the high profiling of this conversation. It has to take place, as I mentioned earlier, it has to take place within and across disciplines.
Juliya?
I also see a question about CDGs and AI, and I think thank you very much for this question, because it's a problem that should be discussed, because it's a little bit unfair competition for businesses who own of this technology, and for countries sometimes where these technologies are developed. And of course, it's very complicated, but the international community should be interested, according to the CDG's agenda, to get some balanced acts. Of course, it's necessary, because I think that without any acts, without any agreements, any treatments, it will be impossible. Of course, it's about monopoly for technology, for IP rights, and so on. And if we are going to this agenda, CDG's agenda, it's necessary to make some frameworks for opportunity for monopoly for this technology and IP rights, of course.
Thank you. We have also additional questions from the floor, so feel free to respond or connect that to your own arguments. But just let me very quickly build on what we have just had. So we see that AI is posing different challenges to countries around the globe. And there seems to be a need for a more pluralist understanding of regulatory responses, because we can see that there have been very divergent and very kind of differing regulatory responses from different countries, perhaps due to the ongoing debates about ethics, AI's legal personhood, fierce technological competition between major players like US, China, Japan and European Union, or the conflicts between or cooperation between big techs along the global supply chain, among other cultural and social divergences, right? So it will be very challenging to reach either universal understanding of AI and how to address the potential challenges posed by AI, and also let alone a unification and standardization on artificial intelligence governance. And also, I also see that there's a possibility of reframing or reconceptualizing the global North and global South as we traditionally understood in the more traditional sense of global trade, because countries with big data support and AI technologies may not be the global South anymore in the new digital age. So we have a kind of new digital divide here, and we see that the reshuffling of global North and global South, which can be challenging for further negotiation or kind of collaboration. So maybe we have more questions from the floor. So Juliya or Mariela, would you like to add anything in response to the questions and comments?
I think I'm going to follow up on what you were also just mentioning, Ching-fu, before I move on to answer one of the questions from the audience. I think I totally agree with what you're just saying about the reshuffling of the global North and South. That's something that perhaps many of us have not seen coming. We got used to think of trade, international trade law of North-South geographically as it is. And now with the advent of the fourth revolution and everything that technologies are enabling us, we are able to do this reshuffling in a way that is more socially justice, that apologies, that promotes social justice and redistributes the resources that we have in this earth in a more equal manner. So in that sense, I think we can make use of WTO law or trade economic law for the social good, even though I am aware that many scholars in the field that do not see that as necessary. It should be only about law and economics and nothing else. I think while I don't completely disagree with that line of thought, I think nowadays it's challenging to avoid thinking about other values that go beyond law and economics. And this reshuffling of the North-South divide is very much needed. That said, perhaps I can answer one of the questions that I'm reading here about AI limited in access to data, whether that would work in the same way of a highly regulated AI, and whether the access to data is the enabler of a successful app based on AI. I'm not quite sure that here the key is a highly regulated environment for AI to perform what's intended to perform. I think I would approach this from the perspective of regulation as an enabler of new technologies. So you want, due to the nature of the technology, you want your AI to have as much access to data as possible. You need that, as I think I mentioned earlier, you need that for the AI to perform as accurate as possible its tasks. At the same time, you also want to protect privacy. What we were just mentioning with Juliya's presentation, it's imperative that privacy is protected, and also that other IP rights are respected on the way, as Juliya was also mentioning with regards to copyrights. So in that sense, I could see a situation where more regulation of AI and data would lead us to a higher accurate technology. But that doesn't necessarily mean that less regulation would definitely lead to AI not being able to perform its tasks. It really depends, I would say, on the idiosyncrasies of the national legal systems. I think the response would be very different in continental Europe than even in the UK or the US or other countries, beyond the differences on civil and common law barriers. So I think that's something that I will have to think a little bit more about. It's surely a very interesting input. Thank you very much.
Just a very quick follow-up a bit. I'm not sure if this is directly relevant to the AI and data regulation part of it, the question. But another dimension to look at it would be, would extremely stringent data protection law or data localization requirements can be seen as stringent regulation of AI development, right? So we're not targeting, when the regulator is not targeting directly on AI development application, but rather on the free flow of data or data protection or privacy law. Would that, if these kind of data protection law or data localization requirements are so stringent, are they, can they be seen equally as a stringent regulation of AI? That's just a very quick follow-up. Juliya, please. Sorry to.
Yes, according to our discussion, I can say somewhat about algorithm based, and it's not about only data or only AI, but it's a very great problem. According to the it's a problem with inequality. For example, this case with Amazon women labor rights, then they any differences, and it wasn't it was a problem for women to get the job. And I think it one more point for discussion. According to AI, First of all, it's the technology and IP rights, because the programmer, the investor, they try to prepare something for market, something useful for market, like a product or AI apps and so on. But another case is social responsibility, and it's very important to stay in touch with these problems with content. I think so.
We have another question from Professor Peter van den Busch. Do countries which are less respectful of human rights have a competitive advantage in the field of AI? And if so, should such advantage be considered as unfair and be addressed? Which is a very interesting one. Data protection, human rights, and how does that constitute an kind of more laissez-faire, more lenient but unfair environment in terms of trade protection and also AI development? Any either Mariela or Juliya, would you like to quickly connect to your paper? Yeah. Maybe Juliya, would you like to go first?
I'm not sure. Thank you for your question, dear Professor. What is less respectful of human rights? Because in international content, all countries of civilized countries, they decided to be in touch, and it's international legislative. So it's impossible, I think, to be less respectful of human rights and so on. I hope it's impossible. And I think it's very important to, I'm trying to explain my position about the balance between business and investment interests and human rights. Because in different countries, it's not only, for example, in Russia, but so I'm a part of teams who make some research in unfair competitive legislation. And Facebook is the most famous company who was like this way less respectful for human rights. In many cases in Europe and Russia and so on, it was the main point. And I think it's the most bright illustration that it's not about only government, but also it's about business and human rights, about customers, about citizens, and so on. I think so.
It's interesting to see how, if we kind of change the term human rights into other, more concrete terms. For example, if a country has no privacy law or no data protection law, which means that it will be easy for them or for corporations to collect, without any barriers, collect personal data so as to feed and train their AI applications. Would that be seen as a unfair environment, or something? Maybe that's also a kind of elaboration on Professor Peter van den Busch's question. Or but is it that the WTO law cares somehow less about a member when a member doesn't really have any requirements or measures on something, right? It usually works the other way around, that when you apply and impose stringent data protection law and privacy law, which affect trade or free flow of either trade or capital, etc. So the WTO law would come in place. But when you don't have anything in relation to human rights requirements or data protection, I'm not sure how that will play out. But maybe Mariela, would you like to add?
Yeah, I think these are fascinating questions. There are a few elements to unpack, I guess, to to the initial question. On the one hand, we have businesses, as Juliya was just referring to, and we have corporate social responsibility and how businesses used to deal with human rights in other areas, not only in AI. So we have that aspect that we need to take into account also when we talk about WTO law. On the other hand, we also have issues of morality. When we start talking about morality as a value, we have a few precedents within WTO law. I'm not quite sure whether they lead to a satisfactory result. It depends on what your approach is to that. But I think it's also of essence to decouple morality from human rights and also see what's the difference there. And that also touches upon the question, the follow-up comment from Rodrigo in terms of the regulatory environment and AI and consumer decisions. I think again it reflects. It depends very much on the domestic legal environment and how reflective that legal environment is of their own citizens. So I think the regulation can be as light or not light as required as it conveys a reflection of the society it operates in. And that being said, there might be questions being asked about: does AI have any right to morality? And particularly that comes up in the field of copyright, when we see AIs actually as inventors, and also in terms of patents. Do they have rights? Should they have rights? And if they do, how do we accommodate those rights within the WTO system, within the broader global economic governance mechanisms that we have now in place? Do we need something completely new? But I think certainly human rights is an aspect that we need to take into account when we talk about competitive advantages being granted by emerging technologies.
If I may, only 2 words about privacy law and AI. Of course, you know that in China, it's a great, I think, decision. They are using, they called e-justice, online courts, and so on. In different countries, as I know, they have some strategies and they have some programs and platforms and so on, e-justice. But in this country, it's, I think, the first one who used it, and AI is only the tool. It's not the judge. It's not the author. It's not the artist. It's for all types, for all fields, for using AI. It's only the tool. It's my point of view. And so e-justice is not is not a problem for privacy law. And I think it's about maybe some frameworks for programmers, for making these algorithms, for technology in different countries, in Europe, in UK, in US, and in Russia. We've got some legislation, not about AI as it is, but it's about some principles, some features of using this technology by the platform. I think it's relevant decision. You see?
By my follow-up, I'm not quite sure how we are with time, but
go ahead.
With what Juliya was just referring to, I would totally agree with what you're just positing now about having perhaps a code of conduct for programmers when it comes to the implications of AI from a legal perspective. And that's how I tied it up to what we're positing in our paper, which is perhaps AI and IP will push us to move beyond rules-based trade law, economic law, towards a more principles-based approach that has, if not flexibilities, at least it can, or it has the ability to accommodate all these divergent codes of conduct or ways of doing business or guidelines. So in that sense, I do agree with what you're saying, Juliya, in regards to codes of conduct, some principles-based approach.
Thank you.
we just had another question. I guess this is for Mariela. Would you like to take a look? And
how do you perceive the regulation of the use of AI in consumer decision making, where it concerns cross-border trading services, health insurance?
let me maybe.
Services. I'm trying to think about how it might differ from goods, which is the focus of our paper and our research at the moment. We're focusing on trademarks as it applies to goods, but when it comes to services, then the whole other Pandora box opens, and I think at the end of the day, it comes back to the type of responsive regulation that you see at the domestic level and how that is also reflected at the international level. And that's why it's so important to have these international discussions about it. Even though we might not agree on a new treaty, we might agree on guidelines, as Professor van der Bosche was referring to before, or we might agree to a code of conduct at the business level, as Juliya was just proposing earlier. I think there is a lot to do with the domestic regulatory culture and how that interplays at the international level, and that is that requires a bit of deference when we talk about AI and IP in general. Of course, now we are in a globalized society. We don't know if there is a deglobalization tendency, but all things given us now, we still operate in a globalized society, and we still have international law rules that apply. And at least from our perspective, we are trying to find out whether these rules that we have now, especially as they relate to TRIPS, if we can use them, if they're fit for purpose. Can we do something with them? Can we apply them and interpret them in a way that actually is conducive to more technological advancement and good for society? Or do we need something completely different? At the end of the day, I think it's important to have the discussion about it and see where we go from here.
Thank you. Juliya, you have anything to add?
I think that, and I agree with the position of the paper, of Mariela's paper, that now it's the economy of expression, economy of time, economy of our attention. And so, of course, it's necessary to make some rules for platforms where we can use our time, our attention, and so on. And maybe the most relevant decision is to warn the customers that it wasn't only his or her decision. It was prepared by algorithm. I think it's necessary to understand it, and it's important. And of course, it's about responsibility. Who will be responsible for this chance? I think it's very important to make it an act, a legal act. Yeah.
Thank you.
Well, if I may just say, perhaps I completely agree with what Juliya was referring to. I think we briefly touched upon our paper about precisely this, which is that consumers need to be given some kind of warning when they are interacting with the AI and see whether AI should ability to explain their recommendation to consumers and whether they need to be alert to the substitution that took place when we talk about products, but also perhaps to services. And at its core, perhaps what we need to take into account is, as Juliya was also mentioning in her presentation, is what do we consider AI? So how we define AI is going to be critical in mitigating legal risks first, but also in making sure that the technology serves us, and that's where the conundrum starts. How do we find a common denominator of what AI is for legal purposes? Thank you.
So just to quickly, reflect upon, your debate on AI's explainability and also human AI interactions, right? Juliya mentioned about e-justice, where in a court, algorithms or AI are being used as a decision assistance systems for judges. And then Mariela talks about how AI is serving as shopping agents on online shopping sites and for consumers to decide its assistance. And at this moment, at least, AI systems are not fully autonomous, and most AI applications are hybrid in nature, which means that there is a human actor in the loop or either on the loop. So we don't see AI as an independent autonomous actor for now. And this kind of human-machine interactions can play a big role in your analysis, right? You mentioned that, for example, Juliya mentioned that it's just a tool. But then, usually humans are increasingly being submissive to machines and computer-generated numbers or suggestions, right? So, for example, shopping agent or a judicial decision assistant suggest that you go with that direction. You're probably not going to challenge it because you don't know, and the system is probably being regarded as really accurate and helpful, and it's based on millions of big data, etc. So people are being submissive, and also people can be psychologically anchored by these kind of machines or AI, whatever we frame it, right? So how human-machine interactions can play a role in your arguments and also your analysis may be something to kind of carefully reconsider. And also very quickly to touch upon Mariela's comment on explainability, right? How we define AI has been really kind of diverse. But then when we talked about AI applications based on machine learning or deep learning algorithms, most of the time they are not perfectly explainable, right? So when they cannot provide enough transparency or explainability, and they also serve as decision assistant tools. And how do we ensure that they can be accountable? And when there are problems or when there are harms resulted, how can we ensure that there are proper allocation of responsibilities or remedies provided to those harm? Just like a very quick response. Further thoughts, Juliya, please.
If I may, about the responsibility, I know that the main popular point of view for this problem is to make some to think that harm is risky, and it will be the point to make this possible, to be responsible for it. It's not about how do you feel, the concrete person, how this person, he or her, thinking, feeling of something, I don't know, harmful content and so on. But it's about public regime, of course. I think it's possible, and now many countries are thinking in this way.
Mariela, please.
If I might just follow up on both your reflections. I think at this point in time, when, for instance, Juliya talks about e-justice in China, perhaps, we've heard about the robo-judge kind of scenario where we just have an AI making decisions later in the line during a judicial process. I agree that we're not there yet. We can still perhaps see AI as a tool, as an instrument to achieve whatever objective that we feed that algorithm with. However, I don't think we need to we need to take into account that technology still evolves, and what's happening in quantum physics, for instance, doesn't make it far-fetched to think that we will end up having a robo-judge. And then this evolution of consciousness in robotics that might at some point in time happen is not here yet, but it might happen if it continues in this linear progression, will prompt all sorts of questions that regard to us. Perhaps I touched upon earlier on the rights to robots. Or do they have a morality? Are they like humans? Are they equal to humans? Should we treat them as a different sui generis legal legal entity. How are we going to address that? And that has far-reaching implications also in the way we do business globally, because there's plenty of questions. I'm thinking about like 10 different questions that come across if we have in front of us a robot judge. We're not there yet, but perhaps the taking point is that we might be there sooner than what we care to admit. Thank you.
Thank you for the insight. Juliya, any immediate feedback?
I see the question about freedom of speech and AI frameworks. So I think that our discussion sometimes it's about eternal questions for lawyers, because at least they're discussing the ethical AI. How can they get the ethical principles reality for AI? Because it's not only about programmers. Sometimes it's not expected, but we can see some cases then human rights, or according to the question, also the right for freedom of speech, they're hurted because it's only the algorithm, not personality. And I think that as I said, it's only tool. AI is only tool. So even we've got some robotics, some I don't know, some machine like a person and so on. The main problem now for me is trust. Many companies they researched this problem, and many citizens, many people in different countries, they were asked about trust to the algorithms, and it was a very high level of trust to the robots, but not human-like robots, but only algorithm. Because when you click in some button, you trust more than people around you to this algorithm. And now it's not a tendency, because in these 2 years after lockdown and so on, many people are not so excited with algorithms. They can use it, when can try it, and they became to understand that it's not I don't know, the optimal way to make something in internet and digital platform and so on. And it's flaw for lawyers to make some public rules, some strong rules, only frameworks for I don't know, against hitting our rights, human rights. I think so.
Thank you so much. Any further questions or comments from the floor? We have one from Ms. Godot. Article 3 of the EU proposed AI regulation provides starting points for AI definition. Yeah.
I totally agree, because it's urgent technology. It's something new every day. So it's not possible to make the formula of AI in one act. I think it's not the way for legislators.
I agree with Juliya, if I may. It would be a mistake from my view to set up in stone what AI is at this point in time, when we know that it continues to evolve. So we need an agreement on a definition that lacks this rigidity. So it needs to be flexible to accommodate how the technology is advancing. Otherwise, we start from the beginning. And perhaps as the last thought on what both of you were mentioning about the role of trust in the interaction with AI, I'm thinking about how trust can be actually reflected in the law, and whether it has to be reflected in the law. Does it have a place there? Do we need to take it into account when we legislate, or when we agree on codes of conduct? What is the role? What's the value of trust? What's trust as a value? Do we need it in order to have effective responsive regulation, or that's something that goes beyond international economic law, global economic governance? Is that something that we want to engage with? Can we actually decide not to engage with it? And I think that's something definitely that I need to think about a little bit more in the future.
It would be nice to, when we talked about AI definition, it would be nice to break it down into different levels of components, right? From the data stage, how do we collect data and use data flows, etc., and how to, and also the algorithm stage. How do we develop algorithms? How do we set standards and rules for algorithm transparency or explainability, and the outcome kind of prediction or application stage? How do we make sure that they're not biased, they are not discriminatory to certain minority groups, and how we can ensure that their results and creations can be properly protected. So it would be nice to kind of use that definition, but also break it down into different levels, so we don't just refer to AI as a general concept. It will be very difficult to address the potential governance challenges. We need to kind of divide them into different concrete groups and elements, so we can talk about the problems posed by data protection or data collection, data flow, and then address them accordingly. And we can talk about algorithm transparency or explainability, and talk about their IP issues or public moral issues, etc. So we can kind of break it down and do it in a more specific and sectoral sense. So some final comments and questions from Guda. Intuition being applied and underlying process. Yes. If I may, may I?
We haven't this point in our discussion, but I think it's very important. It's about human control on the AI, not only for making decisions, but also for creating something. And now I agree that quantum computers and technology the next day, but now it's very important for lawyers, for legislature, that we're saying only about personality, about human who can control this technology. I think it's the most important point today.
Any final remarks from Mariela, if you want? Do you have any final remarks?
I think perhaps to wrap up what our preliminary research is trying to convey here is that in the way the emerging technologies are developing right now, IP is uniquely suited to address the first issues that we encounter as lawyers. Obviously, not all the issues. We're seeing here issues of human rights, we're seeing issues of business interests, and that are obviously legal issues that we will eventually need to take into consideration. But IP as a tool to start a conversation as to how we interact with AIs and how we use the available tools in international economic law, I think it's a great tool to use, and to use it as a bridge to a more broad discussion about other rights that inevitably we will have to consider as lawyers, as Juliya was saying. So thank you for this.
Thank you, Mariela. Juliya, no further final remarks from you?
Like a final remarks, I'm glad to be here, and thank you, my dear colleagues and our respectable audience for the questions. I think it was very fruitful for me. I hope for you too, because we can see that there are too many questions, not for only one section, but actually we can see it, and we should discuss it to make some ways to be ready to make some legislative decision, and I think it will be very, very useful for us, for all of us. Thank you very much for this event.
Indeed. Wow. That was a really thought-provoking discussion we just had. You know that we have only 2 speakers today, a very cozy panel, but we have really fruitful and also amazing discussion today. I believe you all enjoyed this fascinating conversations as much as I did. With this great success, I would like to announce that our panel today on artificial intelligence and intellectual properties is now being concluded. I wish you a great rest of the day and enjoy the conference. Thank you all for your participation and support of SEAL 2021. Please keep in touch. I know that we have we share a lot of common research interest, and we're intrigued by all the questions and comments along the process. So please keep in touch so we can have our paths crossed together soon again in the future.
Thank you very much.
Thank you.
Thank you very much.
Take care. Thank you so much.
Thank you. Bye.
Bye.